The mechanics of this obstruction are equally damning. Defendants force applicants to wait an average of 281 days. Over 9 months, you could have a whole baby. We do, here, many times. There were 3,900 new, 42 renewals for each applicant, and that's like it. That's the only amount of guns there are in California. People who have CCWs, that's it. It's a huge state. It's like 10,000 a year for millions of people. Crazy numbers. CCW, criminal charges, and interview. What the heck is that? You know what we would call that if we were talking about abortion as a right, which they do? You would call that an undue burden. You remember that from Casey versus Planned Parenthood? The Los Angeles sheriff now getting sued by Harmeet Dhillon over the Second Amendment, and this one is outrageous. We'll go through the complaint. It's very short, but it's pretty wild because according to the document, if you're in California and you want to get a concealed carry license, they are so slow that between January 24 and March 2025, so over a year in California, they got 3,982 applications that came through. You want a concealed carry license, you submit your application. Of these, they approved exactly 2, which is 0.05%. That's it. It's a disaster. It's intentionally trying to deprive you of your rights, and now they're getting sued for it. So here's what they wrote over at the DOJ. The Civil Rights Division today filed a lawsuit against the sheriff due to this pattern or practice of infringing the Second Amendment rights of law-abiding citizens who want to carry with CCW permits. This lawsuit is the first affirmative lawsuit in support of gun owners filed by the U.S. Department of Justice. Let's go. On March 27, the division initiated the first of its kind Second Amendment investigation due to numerous complaints of unreasonable delays in CCW permitting decisions by the Los Angeles County Sheriff. I'm like, oh, another one came in? Just put it in the stack over there. After analysis of data and documents spanning over 8,000 CCW permit applications, the division today filed suit seeking relief on behalf of Americans. We had Pam Bondi said, the Second Amendment protects the fundamental constitutional right of law-abiding citizens to bear arms. Los Angeles County may not like that, but the Constitution does not allow them to infringe upon it. This Department of Justice will continue to fight for the Second Amendment. Thank you, Pam. Harmeet Dhillon also said, the Second Amendment is not a second-class right. Don't get the words twisted. This lawsuit seeks to stop LA and their egregious pattern and practice of delaying law-abiding citizens their right to bear arms. And if you or someone you know has applied for a permit and you've not received a reply, please contact their email, community.secondamendmentca@usdoj.gov, and go get your justice. If you're a California resident, now's the time, baby. They're going to be processing those like, oh crap, meat suing. Stamp it. Next, stamp it. Stamp it. You know, keep running those through probably. We'll see. But here is the lawsuit. Not a huge one. It comes in from Harmeet Dhillon, who is the #1 fan of LawTube in America. She loves what we do here. She doesn't. And Bilal Essely. I thought it was Bill. Is that his real name or is that a typo? All right, we got a United States of America, Pam Bondi and the DOJ suing Los Angeles County Sheriff's Department and Robert Luna. They say, all right, we've had enough of this garbage. The U.S. and United States of America, we're now suing the Los Angeles County Sheriff's Department and Robert in his official capacity. And we make the following allegations against him, saying the Los Angeles County Sheriff's Department has systematically denied thousands of law-abiding Californians their fundamental Second Amendment right to bear arms outside the home. Not through outright refusal, of course, but through a deliberate pattern of unconscionable delay that renders this constitutional right meaningless in practice. Oh no, we give them out. We give like one out every, 2 years. Saying the scope of this constitutional violation is staggering. Between January 24 and March 25, defendants California, they got 3,982 applications for new concealed carry licenses. And of these, they approved exactly 2. 3,980 still in the stack. Now, that cannot be explained by legitimate disqualifying factors alone. It's ridiculous. This is not bureaucratic inefficiency. This is systematic obstruction of constitutional rights. Thank you, Harmeet. #1 fan. The mechanics of this obstruction are equally damning. Defendants force applicants to wait an average of 281 days. Over 9 months, you could have a whole baby. We do, here, many times. Just to begin processing their applications, with some waiting as long as 1,030 days, nearly 3 years. Actually, I don't even need my CCW. I've already been shot and killed 3 times. Thank you. I live in LA. Yeah. No, I'm dead already, so thank you for that. Oh, I got it. Great. I'm 107 now. Dead. Thank you. The median delay is 372 years. years, which I don't even know how they have good data because they only did 0.05%. These delays far exceed California's own laws and their own statutory requirement. They say licensing authorities must actually give initial determinations within 90 days. This is a flagrant disregard for both the state law and their own constitution, our constitution and their own state law. The human cost is profound, says Harmeet. As of May 2025, approximately 2,768 applications for new licenses remain pending, with interviews scheduled as late as November 2026. You got to go talk to somebody in California. You're like, why do you need a gun? Oh yeah? Well, what's your opinions about this? I don't even know how it works, but man, you got to get out of California. Like if they're taking your guns from you, that's a pretty good indicator. Look what's happening in Canada and the UK. More than 2 years after some applications were first submitted, they've been waiting around. Numerous applicants simply gave up. They just withdrew their applications. Their rights have been infringed and they might be dead already, often after waiting months in a deliberately stalled process. These are not abstract statistics. They represent thousands of law-abiding citizens who have been stripped of their constitutional right to self-defense outside their homes. Now, the Supreme Court made a decision called New York State Rifle and Pistol versus Bruin 2022, and the Supreme Court said this, that the Second and the 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home. It's a right. But here in California, they have constructed an administrative labyrinth designed to frustrate and to ultimately deny this fundamental right to virtually everyone who seeks to exercise their beautiful Second Amendment privileges. This case concerns rights, not privilege. This case concerns more than just administrative delays. It addresses a coordinated effort by the Californians to nullify through bureaucratic obstruction what they cannot deny through law. When constitutional rights are deliberately delayed beyond any reasonable time frame, they are effectively denied. The United States brings this action, and we want to sue. We're going to restore the Second Amendment rights in California, baby. And defendants have systematically violated these laws, and law-abiding Californians need to exercise their constitutional rights without facing years of unjustified delay. Now, the plaintiffs are the United States of America, and the defendant is the sheriff, and he issues the licenses. And his name is Robert Luna. He's responsible for all this madness over there. And the court has jurisdiction. We're suing. Venue's appropriate in your court. And here's the background. In the state of California, carrying a concealed firearm is a crime unless one of several specific exemptions applies. How is that law still on the books? It's just because it's concealed? Like nobody sued on that? Persons with a valid license to carry a concealed weapon issued under the licensing regime are exempt from the general, like they charge you with a crime for that? Not if you're a felon. Yeah, okay. Arizona's laws are much different. Are exempt from the general prohibition on carrying a concealed firearm. In his official capacity, Luna discharges his duties individually through the deputies, and he appoints them to do this. County sheriffs in California, including Luna, they're the licensing authorities, and he has to accept the applications and issue the licenses. Now, a California license to carry a concealed firearm is valid for no more than 2 years, certain exceptions. Under California law, licensing authorities must do the following. Determine whether you're disqualified. So if you're a felon or, I don't know if you're an illegal, do they count that? Within 90 days of receiving the completion application, they should be doing something. They're not. They also should be giving written notice within 120 days. That's all in the law. Now, by letter dated March 27th, the U.S. DOJ called over there and they sent a letter to Sheriff Luna. Hey, Sheriff, we're investigating you. We are receiving a bunch of complaints that you're unduly burdening or effectively denying Second Amendment rights of ordinary law-abiding citizens. Lengthy wait times in processing applications for concealed handgun licenses. It's like, that's interesting. What if you just impose like lengthy wait times for like abortions in California? Like, no. Yeah, we'll license that. And then you can just wait for our approval. And then our approval you'll get approved 372 days later, something like that, right? They would scream that's a constitutional right, which of course that's not even in the Constitution, but the Second Amendment is. So they can just slow roll certain procedures and processes, but not others. Curious. Now, during the investigation, the sheriff, through its counsel, provided information. They said that we had 8,400 applications. There were 3,900 new, 42 renewals for each applicant. And that's like it. That's the only amount of guns there are in California. People who have CCWs, that's it. It's a huge state. It's like 10,000 a year for millions of people. Crazy numbers. Based on the information provided by the LASD through its counsel, well, they got to go through a process. They get a completed application, then they have to interview you. Are you a good person? Do you vote Democrat? Okay. Then we're going to give you your 22 rifle. The LASD received approximately 3,982 applications. As of May 8th, only 2 got approved. A bunch more came in. 1,200 were withdrawn because they're like, I'm already dead. I don't need it anymore. anymore. He's dead now. For the approximately 2,700 pending applications, interviews are already scheduled for as late as November 2026. We'll get to you. Yeah, you can have your Second Amendment right for November 26. And all current abortion needs are also postponed to November 2026. So come on back here and we'll talk about your constitutional rights to abortion back then. The median number of days that the LASD took to advance an application was 372 days. Yeah, it's interesting. The maximum number of days recorded was 1,030 days. And so they say, we're suing you. We're suing under U.S. code. We want declaratory relief. We got privileges and immunities and rights secured by the Constitution, which includes the Second Amendment. It protects the right of law-abiding individuals to keep and bear arms, both within their homes and outside of their homes for lawful purposes. The Second Amendment applies to the states and political subdivisions through the 14th Amendment and the incorporation of the Bill of Rights. Law-abiding citizens carrying concealed weapons is conduct protected by the Second Amendment. Law-abiding citizens carrying a concealed weapon with a license is conduct protected by the Second Amendment. That's Bruin, right? So how is California now charging people with a crime for that? That's what? California state law expressly requires you provide information about a license. Defendants are governmental authorities. They are being sued. They have to process the applications and work with the constitutional rights. So this systemic practice of delaying of the processing of these permits is depriving people of their constitutional rights. They're denying them prompt determination of their applications. They're failing to provide them any meaningful notice of why their application is being delayed. And they're forcing applicants to abandon their constitutional rights. And so accordingly, they're engaging in a pattern and practice of conduct by law enforcement officers that deprives people of rights secured and protected by the Constitution. And didn't they swear an oath to do differently, to uphold and defend the Constitution, which would include the Second Amendment, fellas? Unless stopped by this court, they will continue to deprive Americans, Californians, they're Americans too, most of them, probably most of them, depends on the region, constitutional right to bear arms outside of their homes in California. It's like California, you have to get a permit and then an interview before you can do any of this. So they're suing. Thank you, Harmeet, for bringing this one, and Julie A. Hamill for bringing it, and Bill Bilal is his name. I thought it was Bill, but it's Bilal. Bilal Esseli, saying a declaration that their pattern of practice violates the Second Amendment. A declaration that approving virtually no new concealed carry permit applications is also a violation, and they want a permanent injunction prohibiting Californian sheriffs from continuing to violate the law. Signed off by Harmeet Dhillon, LawTube's #1 fan for the Civil Rights Division. And we love Harmeet here, and we're glad that she's unleashing on behalf of the Second Amendment. We'll keep our eye on this one. We'll see what the judge in California does. Very likely to deny it, but we're opening up the floodgates on this. And if we can say that California's CCW criminal charges and interview, what the heck is that? You know what we would call that if we were talking about abortion as a right, which they do? You would call that an undue burden. You remember that from Casey versus Planned Parenthood? Yeah, it's an undue burden. You can't make a woman listen to an ultrasound and say, you know, it's like beating heart right there. He's like moving around. He's like, don't kill me. You're like, you want to listen to this? Like, it's an undue burden. You can't make a woman do that. Interesting. Well, here, what is this undue burden that's being exercised on your Second Amendment right? You can't even get a gun until you're dead already. So we'll keep our eye on this one. I know in California, things are going to be an uphill battle. We're in the Central District of California. We'll see if it goes to Judge William Alsup, who's handled some others. But we'll, of course, keep our eye on this one. The Second Amendment is a right, and Californians can't take it away from American citizens. Hopefully, the courts agree. We'll be back covering this one. Thank you for subscribing and joining as we do.